Thank you very much. And now the Commissioner Malmström, you have the floor.
Thank you very much, President. Ladies and gentlemen, honourable members, I want to start by thanking the rapporteur, Mrs. Schaake, for the excellent work that you have done on this, of course with input from other colleagues as well. As you say, we will be discussing some very technical elements, but let's not forget that we talk about highly political sensitive issues such as ending death penalty, torture and ill treatment, which is of course key priorities for all the work of the European Union. It is in fact an anomaly that so many countries still have death penalty and that so many thousands of people are still waiting in death row all over the world. But the fact is that actually it has decreased. 140 countries do not apply death penalty today, 98 have legally abolished it, and that is to be compared to 59 20 years ago. So it goes in the right direction, but that doesn't mean that we should rest. There is so much to do. We have of course different tools at our disposal in foreign policy, but trade also can play a very important role, and that's why this report is so important. Trade can be a leverage to promote around the world European values such as human rights, sustainable development, fair and ethical trade, fight against corruption, and those values are the pillars of the newly proposed trade strategy by the Commission. The regulation we are talking about, 1236/2005, takes this account, the role of trade, to restrict foreign trade in goods that could be used for executions, torture or ill treatment, and we welcome very much the effort done by the European Parliament to amend the regulation. And we largely share the spirit and the approach taken by INTA, the rapporteur and the Parliament, although some of the amendments in the report calls for measures without precedent in export control legislation and can be a bit difficult to implement in practice. We support several amendments, such as Amendment 6, extending the proposed definition of broker to cover national for member states not resident or established in the Union. This is acceptable in principle. It could, though, be difficult to enforce, so the inclusion of foreign subsidiaries of legal persons incorporated in the EU should, of course, not go beyond what is compatible with international law. Amendments 9 and 10 on transport of transiting goods whose export and import is prohibited by the regulation are also acceptable for the Commission if Amendment 10 does not cover more than non-Union goods. It's related to Amendment 15, and that can also be accepted. We just have to make sure that it is formulated in compatibility with WTO requirements. Amendment 21, referring to the transmission of information to human rights oversight bodies, is also acceptable. Of course, here companies requesting an export authorisation that submit information to competent authority have a legitimate interest in not giving certain data and making them public, so we need to make sure how the text is drafted here. Furthermore, we can accept amendments 18 on best practices for technical assistance, 19 on guidelines, and 26 on the report published by the Commission on the implementation, if you can agree that it is not an obligation for the Commission. We can also accept Amendment 2, adding human dignity, and then several other more technical amendments that I will not go into now. I mentioned that some of the proposed measures are without precedent in export control legislation. Last spring, you approved here in the Parliament Regulation 479 on common rules for exports, which confirmed the basic rule of trade policy, that exports are to be free unless trade restrictions are necessary to achieve an accepted objective, such as the protection of public moral. Torture, ill treatment, death penalty are of course never acceptable, but we just need to make sure that trade restrictions to promote respect for human rights meet the necessary test. And in this regard, while we fully understand the rationale of you to propose an end-use or catch-all clause, we think it could lead to the introduction of restrictions going beyond what is necessary and preventing a level playing field for exporters. This can present a challenge to the uniformity of the Union's trade policy, and for this reason the Commission had instead proposed the urgency procedure, which would help us to deal with most of the cases that could be addressed in a more proportionate manner. But we are willing to see if those objectives, which are basically the same, can be reconciled in a formula that we can agree upon. Regarding the amendment on the definition of brokering services, number 5, it would make the regulation cover a range of activities, financial services, insurances related to goods that are outside the Union, and that would be very difficult to monitor and control. But rather than amending the definition, we could identify which restrictions on which services that need the necessity test and then use specific drafting to regulate those activities. And we do recognise the usefulness of a coordination group, and we share the objective behind that amendment. We just need to be very careful to make sure that that article is not at odds with agreed arrangement for delegated powers in the treaty. We would need to find an appropriate formula to create a forum for consultations between Member States, stakeholders, civil society and the Commission. Ladies and gentlemen, as you know, the EU works towards the abolition of the death penalty in all countries. The countries that are included in the proposal, in the authorisation of the annex, have ratified the second optional protocol to the International Covenant of Civil and Political Rights without reservation. So they agreed to abolish the death penalty. When controlling exports to prevent EU involvement in executions in third countries, we should focus our efforts on countries that have not abolished it. And therefore, we disagree with amendments 33, 35 and 37, because there is nothing to show that these countries concerned would have applied the death penalty despite the ratification of the protocol. But let me conclude, it becomes rather technical, by expressing my conviction that this report by the rapporteur and many of you who have been involved in it is a very good basis for further work to make the regulation into a more robust export control regime that promotes respect of fundamental rights without unduly restricting foreign rights. And I express here the full commitment by the Commission and me personally to work with you and with the Council to achieve that objective and a good final product. Thank you very much, Mr. President.
Thank you. Commissioner, I totally agree with you on the penalty. E ora la parola all'onorevole Lochbihler.
Herr Vorsitzender und sehr geehrte Frau Kommissarin Malmström! Exporte von Folterwerkzeugen, medizinisch-chemische Produkte für sogenannte Giftcocktails für Hinrichtungen,